for over 2 decades without being fully implemented, you have to ask why. Usually it's because of money or politics or simple bureaucratic inertia, but sometimes it's because the law itself simply doesn't make sense. That's exactly what happened this past Monday at the Constitutional Court of South Africa. The court confirmed a High Court ruling that struck down sections 36 to 40 of the National Health Act of 2003. Those sections were never fully operational, and now they never will be. The core of the ruling is about something called a certificate of need, but to understand why the court threw it out, you have to go back to what the National Health Act was supposed to do in the first place. Let's look at the National Health Act of 2003. The legislation was designed back then to create a unified, structured health system for the country. At the time, South Africa was still dealing with the fragmented health authorities from the former homelands and different provincial governments. The goal was to bring everything under one national framework. The Act had several core objectives. First, to unite the health system so that everyone was working toward the same national goals. Second, to establish cooperative governance across national, provincial, and local levels. Third, to promote equity and efficiency through decent management. And fourth, to encourage public-private cooperation and shared responsibility. Over the years, different parts of the Act were switched on at different times. The initial chapters came into effect in May 2005. Section 53 started in June 2008. Significant sections around licensing and quality followed in March 2012. But sections 36 to 40, the certificate sections, never really got off the ground, and now we know why. So what exactly did those sections say? They proposed a certificate of need system, and on paper the idea sounds reasonable. Now we move to the mechanics of the certificate of need. Under these provisions, a healthcare professional would have been required to get state permission before doing several things: establishing or expanding a healthcare facility, acquiring high-technology medical equipment, providing certain prescribed healthcare services. And here's the kicker: even continuing to operate an existing practice. So, if you were a doctor with a small clinic that had been running for 10 years, you would have needed a certificate to keep your doors open. That is not a small administrative burden. That is a fundamental shift in how private practice operates. Now, why did the Department of Health argue this was necessary? Their case, presented by Acting Director General Professor Nicholas Crisp, rested on Section 25 of the Constitution, which guarantees the right of access to health services. The government's intent was to correct what they saw as a severe maldistribution of healthcare resources. Consider the numbers: approximately 84% of the population relies on the underfunded public system. Only about 16% uses the private sector. And private practitioners tend to cluster in affluent urban areas like Sandton, not in rural or underserved communities. The government wanted a mechanism to force new graduates and existing practices to move into less served, even what they called inhospitable areas. They also argued that the certificate system would provide a regimen for licensing and monitoring quality. But the court looked at this framework and found multiple fatal flaws. This brings into question the grounds for unconstitutionality. The first and most direct finding was that sections 36 to 40 infringed on section 22 of the Constitution, that is the right to choose a trade, occupation, or profession. The court ruled that the state did not have a justifiable reason to restrict where a professional could practice, especially when the restriction itself did not directly improve rural care. You cannot fix a shortage in one place by shutting down services in another place. That leads to the second flaw. Rationality. Professor Alex van den Heever, who testified in the matter, described the legislation as irrational, not because the goal of equity was wrong, but because the proposed framework could not reasonably achieve that goal. Professor Benjamin Smart made an even sharper observation. He called it a zero-sum fallacy. Reducing services in affluent areas might bring the country closer to some statistical medium level of equity, but it does not actually improve the standard of healthcare in rural areas. If you close a clinic in Sandton, a patient in the Eastern Cape does not get a new doctor. The only thing that changes is that fewer people have access overall. And crucially, there was no solid evidence presented in the legislation to show how these provisions would practically achieve their stated goals. The government was asking the court to accept a theory without data. The third flaw was excessive ministerial discretion. The framework was what experts called a command and control design. It deferred critical implementation details to future regulations, which meant the Minister of Health and the Director General would have had enormous power with very few guardrails. The court has historically been skeptical of laws that give the executive branch that much room for arbitrary decision-making. And finally, the Board of Healthcare Funders argued that Parliament had failed to allow for meaningful public participation during the legislative process. Academics and experts noted that their inputs were largely ignored. One description of the process was that it involved more politicking than genuine collaboration, so the court struck the sections down, but that leaves the Department of Health in a difficult position. We now move to the government's response. Professor Crisp accepted the court's decision and said the department would not seek rescission, but he expressed genuine concern that the ruling creates what he called a lacuna, a vacuum in the law. His argument is this: without sections 36 to 40, there is no clear provision allowing for the licensing and distribution recognition of health facilities. Most provinces currently rely either on Section 40 of the old 1977 Health Act or on the now invalidated sections of the 2003 Act to issue hospital licenses. He found it strange, in his words, that the court suggested current licensing was sufficient, because in his view, it clearly is not. That is not a small disagreement. That is a fundamental gap in how the state monitors where private healthcare facilities are located and whether they meet basic standards. But academics and public health experts argue that the government has been focusing on the wrong problem entirely. Now we move to the deeper systemic issues. Professors Smart and Heever both pointed to economics and management, not location, as the real obstacles to equitable healthcare. Smart cited the 2 billion rand corruption scandal at Tembisa Hospital as a primary reason why the middle class resists further health taxation. When people see that kind of waste and theft, they do not want to put more money into a system they do not trust. What is needed, the experts argued, is improved administration, fiscal responsibility, and an end to corruption in government facilities. Restricting where private practitioners locate does nothing to fix a corrupt hospital. It just irritates the doctors who might otherwise be willing to help. And that brings us to the elephant in the room, the National Health Insurance Act of 2023. Now, we move to the relationship with the NHI. Professor Crisp was careful to clarify that the NHI has not been operationalized. It is currently in what he called a holding pattern, awaiting separate court judgments. The legal case we are discussing today was specifically about the National Health Act of 2003, not the NHI. But here is the connection that experts are watching closely. Professor van den Heever argued that both the Certificate of Need system and the NHI share a similar command and control mindset, the same centralized approach, the same heavy reliance on ministerial discretion, the same deferral of critical details to future regulations. The invalidation of sections 36 to 40 suggests that similar mechanisms in the NHI may face constitutional challenges on the same grounds. Exercise of discretion, protection of professional rights under Section 22, and the basic requirement of rationality. If a law cannot demonstrate a clear, logical link between the restrictions it imposes and the outcomes it promises, the court is likely to strike it down. Professor Smart put it even more bluntly. He said, the NHI promises more than it can deliver. The private sector can only accommodate roughly 20% of the population. So the promise of universal private standard care is, in his word, impossible. So where does that leave us? Now we move to the critical takeaways. First, the court did not rule against health equity or universal coverage. That is an important distinction. The judgment was not about whether the goal is valid. It was about whether the method was rational, and in this case, it was not. Second, the Department of Health now has a genuine regulatory vacuum to fill. They need to find alternative legal avenues to manage the distribution and licensing of health establishments. That is not an easy task, but the court has essentially told them to go back and design something that actually makes sense. Third, the ruling reinforces Section 22 rights in a way that will reverberate beyond this single case. Any future healthcare legislation that adopts a command and control approach will need robust guardrails and a clear, rational link between the regulations and the intended public health outcomes. The days of passing broad, delegating statutes and leaving the details to the minister are on notice. And finally, the expert consensus suggests that equitable access will only be achieved by significantly improving government healthcare facilities themselves, better administration, fiscal responsibility, and end to corruption. You cannot redistribute your way out of a broken system. You have to fix the system. The Constitutional Court did not say South Africa cannot pursue health equity. It said you have to do it lawfully, rationally, and with respect for constitutional rights. That is not a barrier to reform. That is the baseline.